Hey everybody, Roger Thorpe, president of Thorpe Benefits here. I'm joined by a couple of industry experts, and we've wanted to arrange this legal conversation for quite some time now. I'll ask everyone to briefly introduce themselves in terms of why they're here and what they have to offer.
Yeah, my name is Jason Hubbell. I'm a consultant with Open Access, and we are specialists in pensions and retirement savings. We work with employers and advisors across Canada as a record keeper and also a fiduciary managing investments and retirement plans for group retirement solutions.
And I'm Roger Thorpe, just in case anyone doesn't know. I'm the president of Thorpe Benefits. We're a integrated benefits and wellness consultant, and we're hired most of the time through senior level HR and finance roles as an upgrade from traditional benefit management. So the legal side of benefits, that's what we're here to talk about today. Dante, I'm going to jump in and throw the first question, but maybe you could introduce yourself.
For those I haven't met, my name is Dante Manna. I am a partner at Stewart McKelvey Law Firm in Halifax. I do labor and employment law with a specialization in pension and benefits law. And I work with a lot of employers sort of across the country who have employees across the country and pension plan administrators and benefits plan administrators.
One of the most prevalent topics of conversation these days in the news, amongst employers, and all surrounding our benefits coverage is about the rising cost of living and how employees can manage their own financial priorities. Questions have been raised by employees if they can stop their retirement contributions or stop paying their benefits coverage to sort of mitigate those costs. With that in mind, the question that we have today is, can employees legally opt out of their benefits coverages?
Thanks for that question, Jason. Happy to share my comments. Again, these are aimed at private sector companies and do not constitute legal advice. So, yes, employees can opt out of benefits coverage or even pension plans. The key would be that the employee has to waive their rights to participate in writing, but by doing so, they can opt out of any benefit so long as the benefit is not mandatory. And so the question here is really which benefits are mandatory, which benefits are optional. And you have to take that on a benefit by benefit basis. So we discussed earlier that there are certain statutory minimum leaves, such as vacation, holidays, in some jurisdictions paid sick leave. Those are mandatory benefits that in most cases the employee can't simply opt out of. Subject to any minor exceptions that are actually built into the statute itself. So for example, in Nova Scotia, if you're an employee who works less than 90% of regular working hours during a 12-month period, there is an exception where you don't have to take your vacation. I don't know who would opt to not take their vacation, but the employer would still have to pay you your vacation pay. But you could waive that in writing, even though it would otherwise be a statutory entitlement that you would have to take. There are also statutory limits that may prohibit opting out of statutory benefits programs. So, workers' compensation, if you're covered, employment insurance, Canada Pension Plan, things like that. Of course, an employee could decide not to accept the benefits, or once they retire, they could donate their CPP. But regardless of that, the employer would still, generally speaking, have to withhold and remit on their behalf where required by statute. So CPP or Canada Pension Plan and EI, employment insurance deductions, those are always required up to a certain age and limit, whether or not the employee has advised the employer that they do not intend to use them. So some of those things you can't waive. Also, for employer-sponsored pension plans, the plan documents would set out the mandatory benefits from the optional ones and the mandatory contributions, the required contributions from the voluntary contributions. So as we discussed, employer-sponsored pension plans are generally regulated by pension standards legislation, as well as the Income Tax Act. And that to some extent prescribes the contractual terms of a pension plan. And it's not terribly common for employees to opt out, but we have seen some employees request exemptions from participation in a pension plan, even when it's mandatory. based on religious grounds. I understand there are some religions which strictly prohibit earning interest, and the typical plan terms sometimes do cause issues with the observance of some religions, particularly Islam. I'm aware there are specific products being developed, such as a so-called Sharia compliant defined contribution pension plan that some employers have been able to offer as an alternative to accommodate their employees' religious observance. But generally speaking, we follow what's in the plan text. On the note of religious observance, we also discussed the effect of human rights legislation, which prohibits discrimination against employees on the basis of certain protected grounds, right, such as age, race, gender, family status, mental or physical disability, religion, several others. But we discussed that in making changes to benefits, those changes should not be discriminatory. So I think it's important to understand that even though I'm saying employees can opt out, it is important to note that even if you are opting out of a benefit, if it ends up being a discriminatory pension or benefit scheme, that might not help. So for example, in the example we discussed where the employer decided to end a parental leave salary top-up benefit for women but not men because the claims from women were too expensive. Even if the employer said, okay, well, women, we'll have you opt out, and then everyone signed something. Even if they did that, that could still be seen as discriminatory because there would still be that inequity on the basis of gender. I mean, unless the people who were opting out were given something potentially of equal value. But there is something to note that opting out doesn't necessarily protect you on that ground. So even if all the women signed waivers opting out of the top up, it should not be considered to affect actual legality of the change to the program. So finally, for employees who are represented by trade unions, we discussed the risk that the benefit change without the consent of the union would be in breach of a collective agreement, which would entitle the union to grieve and have those benefits reinstated. So, as we said, the degree of that risk depends on the degree into which the benefit is incorporated into the collective agreement. And the example we gave was the collective agreement explicitly provides 4% matching RRSP contributions. If that's the case, that would be collectively bargained, and the employee's individual waiver may not be effective without the union's consent. So in short, an employee who's in a bargaining unit represented by the union, if they want to opt out of a benefit, it's a best practice to also have the union signing off. And if needed, even enter into a letter of agreement that could be appended to the collective agreement to further document the union's agreement to those employees who've opted out.
So on the retirement side, when we are talking to employers about legally opting out of their retirement programs, it really comes down to the plan text, because pension plans especially are dictated to what rules are stipulated inside that plan text. If the plan text allows an employee to opt out, they'll need to provide written notice, like you said, as far as the contractual agreements of the plan and the Income Tax Act of Canada and the regulatory framework around that does generally allow employees within the context of the plan text to opt out of their contributions. Generally speaking, employers who offer a pension plan must contribute a minimum contribution unless that employee is opting out of a mandatory program. On the group RSPs and deferred profit sharing plans, the framework around that is a lot less restrictive. It's a little bit more malleable as far as what options need to be followed. But generally speaking, RRSPs are a voluntary program, and an employee opts out of that, the employer is not obligated to contribute to it.
In any case, an employer should ensure that the waiver forms they use with individual employees to opt out have been reviewed by legal counsel and are drafted in accordance with drafting best practices.
So Dante, on the subject of opting out, we communicate regularly and repeatedly to HR teams about the rules of mandatory contracts. So it's easy sometimes as a plan administrator, maybe not to know what those rules are if you're just administering the plan from a day-to-day basis. I would say reminding those administrators or those leaders that the plan for group insurance rules to spread risk properly, we need everyone enrolled on the plan. So opting out, unless it's a spousal waiver by that definition, is not allowed. So repeatedly reminding plan administrators of that rule is important. And of course, we don't also want plan administrators to get into a negotiation with their employees on who's in and who's out. That's a very difficult position to be in. So these mandatory rules actually make their lives a lot easier.
Yeah, thanks for that, Dante. We really always, from our perspective, try to encourage those opt-out forms to be signed and reviewed regularly, just from covering all bases when we're looking at these opt-outs. Thank you very much for that answer.